Visa denial for a custodial parent hits different than losing your keys, because this time the lock is a federal consulate window. You are dealing with something called consular non-reviewability, which is a fancy way of saying courts usually will not second-guess a consular officer's yes or no. That sounds scary, but it is not the end of the road, so stick with me. First thing you do is get the actual reason for denial, because visa refusals come with a code, like 214B or 221G. 214B usually means the officer thinks the parent will not go home, while 221G means paperwork is missing or more review is needed. If it is a 221G, that is actually the friendlier letter, kind of like a teacher saying redo your homework instead of you fail forever. You gather the missing documents, financial proof, custody papers, ties to the home country, and resubmit through the same consulate. If it is a 214B, that is trickier because it is about the officer's judgment call on intent. An immigration lawyer can help build a stronger application showing strong ties abroad, a clear travel purpose, and proof the parent plans to return, almost like packing extra evidence instead of extra socks. Now here is where custody law and immigration law crash into each other like two group projects that were never supposed to meet. If the parent has full or partial custody, that custody order becomes powerful evidence for the child's connection to the parent and for humanitarian arguments later. You might be wondering if the child in the United States can just petition the parent, and the answer depends on age and citizenship status, since a child usually cannot sponsor a parent until that child turns 21. That gap between a young kid needing a parent now and immigration law's patience for turning 21 is where most of the heartbreak actually lives. In the meantime, families often look at humanitarian parole, which is basically the government saying come in temporarily for an urgent reason, even though the regular door is shut. It is not a golden ticket, approval rates vary, but it exists for situations like medical emergencies or a child's serious welfare needs. Some families also explore a waiver if the denial involved a specific bar, like unlawful presence, and yes, there is real paperwork called an I-601 that basically begs an exception based on extreme hardship to a qualifying relative. Extreme hardship is not just sadness, it is documented, specific, provable hardship, more like a court case than a diary entry. Here is a myth worth squashing right now because people think a lawyer can just call someone and fix it like customer service. Immigration attorneys do not have a backstage pass to consulates. What they actually do is build the strongest possible legal argument and know which forms, deadlines, and evidence carry weight. Data-wise, refusal rates for certain visa categories have hovered anywhere from single digits to over 50% depending on the country and visa type, so this is not rare. It is common enough that entire law practices exist just for this problem. That also means you are not alone, and panic is optional even though it feels mandatory. One practical move is requesting an expedited appointment or reapplying with a completely refreshed file instead of just resubmitting the same week's stack of papers. Think of it like handing in the same failed essay again versus actually rewriting the thesis. Custody documentation should be translated, notarized, and clearly show legal authority because a messy or incomplete custody order can quietly sabotage an otherwise strong case. Judges and officers like clarity. They do not like guessing games. They are not trying to solve a riddle, they are trying to confirm facts. Timing matters too, since some waiver processes and appeals can take months, occasionally over a year, so families need a parallel plan for the child's care and stability during the wait. That is not pessimism, that is just being the responsible adult in a chaotic situation. The real takeaway here is that a visa denial is a setback, not a verdict, and the right legal strategy often turns a hard no into a conditional maybe. Preparation, documentation, and picking the right path, whether it is a waiver, an appeal, or parole, usually matters more than luck. So if any of this hit close to home or made you go wait, does that apply to my situation? Do you want to learn more about how we help families untangle exactly this kind of mess? Check out our links in the description for more.